Hello everyone, I am Kirtan from Sri Venkateswara College of Engineering, Bangalore. Today my assignment topic on partnership, including LLP. Indian Partnership Act 1932. In term, partnership is defined under Section 4 of Indian Partnership Act 1932 as under partnership is an agreement between two or more persons who have agreed to share profit of the business carried on by all the one of them acting upon all came into existence on 1 October 1932. Partnership refers to an agreement between persons to share their profits or losses arising on account of actions carried by all or of them acting in behalf of the persons who have entered such as agreement called partnership. Partners give their collective business a name. The relation between partners arises out of contract or an agreement, which means a husband and wife carrying a business or members of a Hindu undivided family are not into partnership. The share of profits received by an individual from the firm, money received by a tender of money, salary received by a worker or servant. Nature of partnership. Association of two or more than two persons. Results of agreement between two or more persons. Agreement must be share profit of the business. Business must be carried on by all of them acting for all by any of them acting for all. Share of profits and business. Restrictions on transfer of interest. Agreement must be carried on some business. Types of partnership. Partnership for a fixed term, free to fix the duration. Rights and duties of partners continue to be the same unless they have been changed by an agreement. Particular partnership, where two or more persons agree to do business in particular adventures or undertakings. Partnership at will. No provision is contract between the partners for duration of the partnership. It has no fixed defined date of termination, so death or retirement of does not affect all existence of partnership. Types of partners. Active partner, sleeping partner and nominal partner. In that active partner who takes an active part in the management of the business is called active partner. He may also called as actual partner. Sleeping partner. A sleeping or dormant partner is one who does not take any active part in the management of the business. He contributes capital and shares of the profit, which is usually less than that of active partners. Nominal partners. A partner who simply lends his name of firm is nominal partner. He either contributes any capital nor shares in the profits to take part of management of the business, but he is liable to third parties like other partners. Partner in profits. A partner who shares his profits only without being a liable of losses is known as partner in profit. He does not take part in the management of the business, but he is the liable of third parties for all the debts of the firm. Partner in holding out. Strangers who themselves represent themselves to be partners in the firm, they induce others to give credit to the partnerships are called partners in holding out. Reconstitution of a firm. When there is any change in the composition of partnership, it is reconstruction of partnership firm. The reconstitution takes place when a new partner is admitted or a partner expires, a partner is expelled, a partner is declared insolvent, a partner dies, a partner transfers his interest to another person. Dissolution of a firm. Dissolution of a firm means a firm ceases to exist. The relationship existing between the partners discontinues. Dissolution of a mutual agreement. The very first and easy way to dissolve the firm is dissolution of agreement. A firm may be dissolved with the consent of all the partners, or partners may enter into an agreement to dissolve the firm, provided that when more than one separate adventure of undertaking is carried one of by the firm, the legality of the one or more shall not of itself cause the dissolution of the firm in the respect of its lawful adventures and undertakings. Limited liability partnership. A limited liability partnership is a partnership in which some of all partners depending have limited liabilities. In an LLP, LLP is nothing but limited liability partnership. One partner is not responsible for liable of an another partner's misconduct or negligence. Limited Liability Partnership Act 2008. The Act came into force on 31st March 2009. It combines the advantages of both company and partnership into a single form of organization. The liability of the partners would be limited to their agreed contribution in the LLP. The limited liability partnership is managed as per the LLP agreement. Advantages of LLP. Body corporate. LLP is a body corporate, which means it has its own existence in compared to the partnership. Liability. A LLP exists as a separate legal entity. Liability of a repayment of debts and lawsuits incurred by the LLP lies on its not the owner. Perpetual succession. The LLP will be the same entity with the same privileges, immunities, immunities, estates, and possessions. The LLP shall continue the exist towards the wound of according to the provisions of relevant law. Flexible to manage. The most freedom managed is to own the affairs. Partners can decide the way you want to run and manage the LLP in the form of LLP agreement. Easy transferable ownership. It is the easy become partner to leave the transfer and ownership in the accordance with the terms of LLP agreement. Disadvantages of LLP. It cannot raise money from public. Under some cases, liability may extend to personal assets of partners. How to form a LLP? This is the formation of the LLP. Step 1, Step 2, and Step 6. Key requirements from LLP: partner, contribution, and designated partners. At least two persons are required to form a LLP in case of body corporate, and they will be required as nominate persons as its nominee. These are all the comparison of partnership, and limited liability partnership. Thank you.